friends. Good evening. I hope everybody's doing fantastic. Today, we're going to be discussing a very important topic, something that is happening recently with a lot of cases that I'm personally observing. When you are hoping to get a green card, you're filing your documents for a green card, and instead you are ending up in removal proceedings. So we're going to talk about what's going on, how is it possible, and why it's happening. Please join me. My name is Alina Shaltsova. I'm an immigration attorney from New York. I regularly hold these live sessions to help you guys out, basically, to answer your questions live, to update you with regard to the most recent trends in immigration, how USA is dealing with this and that issues. Also, of course, we're discussing various topics of the immigration law, and I'm answering your questions live. If you do need to consult with me personally, please reach out to my team by calling 917-885-2261. And don't be shy. Let me know where you're watching from. Say hello. Type up your questions. Like and share the stream. Send me hearts if you're watching me on TikTok. Share this stream and ask your questions. We're discussing immigration questions today. And at the beginning, I'm going to be focusing on adjustment of status process and why so many people these days find themselves in deportation proceedings instead of getting their green cards when they file for adjustment of status. Form I-485 that you're submitting with immigration, one of the most frequently filed forms, an expensive form too. You, in most situations, are going to pay $1,440 for it. And imagine after you pay that and you submit all these documents, instead of getting a green card, you're going to end up in deportation proceedings. So let me talk about this with you. Form I-485 usually is filed together or after. Basis for your green card is filed either together or is already approved, right? So basis for the green card usually would be Form I-130, petition by alien relative, for alien relative. I-360, this is the form that can be filed by a variety of applicants. For example, those who are filing for SIJ status, VAWA applicants, widowers, special immigrant visa applicants, I-360 form. Also, this form may be filed, for example, by a religious organization for someone they would like to employ in the United States on a permanent basis. Form I-140, that's a petition for alien worker. You can self-file it. You file it by yourself, for yourself, or your employer submitting it for you. So these are the most common forms that are going to be filed together or after or prior to Form I-485 being submitted. But this is not the only case. For example, you may win asylum and then you file Form I-485. You may win U visa or T visa. So the situation may vary. And then you file your application to register permanent residency in the United States or a green card. In other words, and during this important step, the government is checking and rechecking your eligibility for the green card. It's very, very important step. They're going to check if you are admissible, if you have any criminal arrest convictions, charges that may prevent you from getting a green card in the United States. If you may become a public charge, if everything was done correctly during the step when you were filing for Form I-130, I-140, I-360, things like that. They will also check if you filled out the form correctly, if you submitted your medical exam, and sometimes they send you an RFE, request for more evidence. And what I've recently started noticing that very often somehow the government says that they sent you this RFE, request for more evidence, where they could have asked for something very trivial, something like a copy of your birth certificate with a translation again. They're stating that they mailed it to you, but you never received it. But because you did not reply to it, did not respond to it, they're saying that now they're closing your case and your adjustment of status is denied. Now you're losing that huge fee that you paid and your adjustment of status is denied. You're not going to get what you wanted because you did not reply to the RFE. And I have been seeing that a lot recently. Sometimes people swear to me that they never received the RFE. It was never mailed to them. Nevertheless, government just denies their case. And other times, what happens is that a person who was in legal status submitted for adjustment of status, but previously, prior to submitting for this adjustment of status, they filed for an extension of their legal status and then they abandoned it because they thought, well, now I have green card application pending. Why would I need to invest more time into answering the RFEs for in connection with a different application that I don't need right now? But when they don't answer RFE in connection with a previously filed application to extend or change their status, the government, the branch of the government, the office of USCIS, same office that deals with adjustment of status, only maybe a different person, registers the person as out of status and automatically sends them to immigration court. You may have still adjustment of status pending before USCIS. You may have motion to reopen pending with USCIS after the denial. You may have something else is pending or nothing is pending, but because technically you don't have lawful non-immigrant status and just something pending, they send you into deportation proceedings. They place you in removal proceedings with immigration court, and that's how you end up before a judge. The good news that in most situations, if you previously filed everything correctly, you will be able to get adjustment of status granted even before a judge. But of course, it scares you very much, and you still have to follow the necessary steps in immigration court now, which is very important. Sometimes you'll have to refile for adjustment of status in court, which is going to cost you a lot of money these days, $3,000 almost, right? Sometimes you will have to ask the judge to terminate the case depending on the situation. And if the judge agrees, the prosecutor agrees, you may get out of those proceedings. But the point is that recently, the government started placing everyone in those immigration proceedings. And it happens more often than before, much more often than before. And you don't have to worry about it. You just have to take care of it calmly with a knowledgeable attorney. You're going to be able, in most situations, you will be able to get out of those proceedings. Remember, you have I-360 approved, but something went wrong with adjustment of status, they place you in removal proceedings, even if motion to reopen is pending. You have I-140 approved, adjustment of status pending, but your extension of status was denied, removal proceedings. You may marry a US citizen, still they're going to send you to removal proceedings, and that is happening a lot. One of the reasons we have a backlog, I'll be honest, in immigration courts. So they're trying to basically sort out those cases in between different agencies within immigration, asking those military people to come in, which I think cost more than USCIS officers, if you ask me, because immigration judge's salary is much more higher salary, right, than a salary of an immigration officer. But what can I say? But that's why you may end up in immigration proceedings. If everything went well, and instead you got your green card, you should be very, very grateful. But there is one more issue that you may encounter even after your green card is issued. It is a post office issue. Again, recently, many people are asking me this question online, and my office actually encountered this issue also once in one case. The government mails you the green card, but the post office is not delivering it. They're saying that they cannot deliver it to you, and they're sending this green card back. I find this to happen sometimes by mistake, unfortunately. But you also need to know about this. It may happen to you, and then it takes time to get the green card back from the government. I think they keep it within their office for 30 days. If you file a service request, they're going to mail it to you. But because they're using USPS, and I guess, maybe, my guess, shutdown somehow affect the government agency, you may encounter this issue as well. Just be ready for it. Not not an unresolvable issue, but it happens these days quite often for some mysterious reason. Okay. But again, if you handle everything correctly, you will be able to get out of this situation too. Here, I just want to spread this news. I want you to be aware that there is a problem. So if it happens to you, you feel a little bit more comfortable and will not think that it is the end of the world. And now, guys, if you have questions, I'll be very happy to answer them. Thank you, guys, for your kind words. Thank you for sharing this stream. Hi, Taurus. Alina, I'm in cancellation removal for master hearing April 2026. After this master, the next court is going to usually be when? I'm 20 years in America with American child of 12 years old. Taurus, it depends on your judge. If you are going to draw one of those judges that are new, most likely your case will be heard within a year, final hearing. If it's one of the older judges, it may take much older, like 2 to 3 years. Okay, that's what it depends on. Hi, Veronica. How likely it is for a judge to reopen an asylum case that was denied 10 years ago? We didn't appeal, but they had threatened us. My family filed police reports and they threatened me on social media. If, Veronica, you can prove change of circumstances, they may reopen the case. Okay? If, let's say, those people who were threatening you before became active again somehow, and you have solid proof of that, you can always file a motion to reopen. All right. How likely it is? Well, it depends on the judge, on the case law, in the place where you reside, where the case is pending, of course. All right. Hi, Veronica. If an adult who has a visa pending has autism, would that disqualify the applicant from coming to the United States? No, I've never heard that autism would disqualify somebody by itself from coming to the United States. Hi, Ahmed. My vow pending for 3 years now. I said my EAD renewal since February 2025. My old EAD category is CO9, but I received my receipt notice. Class category was C31. I didn't receive anything else. What should I do? All right. So, it's very interesting. If your EAD was converted into C31, it may mean that your vow was approved. So check online, order FOIA, see what happened. If you used an attorney, your approval could have traveled to that lawyer's office and it was lost. They didn't tell you what was going on, and that's what it is. So USCIS rarely makes mistakes of this sort. So hopefully your vow was approved, and that's why they converted your work permit into C31. But it could have been also a mistake. I do not know. All right, so you need to investigate this a little bit further. Now, guys on TikTok, thank you for your patience. Let's see what questions we have tonight. Hi, happy morning. Happy morning. Good morning. Good morning, guys. Some of you are watching me from locations where it is morning. I have night time. Thank you guys for sharing the stream. Do they send biometric twice? Yes, sometimes they do, in fact, send you twice for your biometrics. And guess what you need to do? You must show up. You must show up twice for your biometrics. Why? Because sometimes they couldn't correctly capture your biometrics the first time. Sometimes it's just a mistake, but still, you have to show up. Because if they register somehow that you didn't show up for your biometrics, even if they're the ones to blame for the mistake, they will deny your case. You don't want that. It's not worth it. Okay? Hi, Mohammed. I have asylum interview next week. What questions should I expect to ask me? Whoosh, Mohammed, why do you still ask this question if your interview is next week? All right, I don't like ChatGPT at all for immigration purposes, but here is where ChatGPT actually may be helpful because it may give you a good idea. What you will do, you will Put in the chat GPT. If you cannot afford an attorney, okay, if you couldn't afford a lawyer, you wouldn't be asking this question. But if you cannot afford, it's just a matter of how you ask the question. You say, listen, this is my qualification for asylum, and this is what I shared with asylum office. If you were an asylum officer trying to disqualify me for asylum, what questions would you ask me? This would be your chat prompt, okay? Prompt in the chat GPT. Why? Because the task of the asylum officer is to check if you meet asylum qualifications by not trying to find the reason to give you asylum, but most likely trying to find a reason to disqualify you from asylum. Otherwise, you would have received your asylum automatically, right? Because you sent everything, I hope, which is needed for the case. Usually, you need to update your story before your interview if your case has been pending for a while. You need to update your country conditions, perhaps evidence, any new threats, any new developments. Maybe you never sent the story before, so you would have to now share it, right? Questions that they ask first relate to the form itself. They take a form and they go field after field, box after box, verifying that all the answers are correct. They always ask you who helped you to prepare this form. Why? Well, first of all, if somebody who is known to prepare bogus applications helped you, they will red flag your case. Second, if mistakes were made and you say, well, it was not my mistake, I didn't know it was in the form. If you don't share with them at the beginning that someone helped you to prepare your case, they will never believe you afterwards that it was not your mistake. So it's very important to be precise in your answers and explain to them if it was a paralegal, family friend, a person who didn't want their name on the form helped you. Maybe it was a lawyer, right? So you have to tell them. They always ask. And then they ask you about your case. They ask you like why you didn't go back to your country. Why? What are you afraid of? Who are the people who are going to hurt you? Why they would do that? Did they hurt you before? How many times? What happened? And then they verify your answers with your story. And if you give them different answers, this is when they're going to deny your case, saying material inconsistencies between your written statement and your testimony. Okay? So that's what they ask you, but you should really work with a lawyer, guys. Asylum is such a complex law. Eh, it's tough and it's intimidating also when you're at that interview. Hi Nazar, how long they take to respond to NOID? How long you will take? It's only 30 days. They give you 30 days to respond to NOID, but how long they will give you an answer after you submit your response, I do not know because it differs in every case. If you provided them huge amount of documents and they need to take the time to review them, it's going to take them longer. If it was something very succinct, then it's going to take them a shorter time, right? So it depends on the volume of the documents provided, the issues, and if they will conduct a new investigation. Okay. Thank you guys for your gifts. Hey James, thank you. Is there any news in the TV visa processing? No, I haven't had any bad news at least. Haven't had any news. Thank you, Evgeny. Let's see. You can manage a summaries. Okay, notes. The TikTok AI gives me tips how to handle many questions. So it's nice. Hi, Katya. For how long to wait receipt notice for adjustment of status? These days, within 30 days, usually they come. I find that this huge backlog, like this huge wait times are over. They do send notices pretty quickly these days, okay? What does bona fide determination notice? What it means, like practically speaking, nothing, to be honest, but what it means is that your case may have merit on its face, right? That's what it means. And You should have it on you because if God forbid you're picked up by immigration, you say, whoa, yeah, listen, I have this bona fide notice. Give me time. These notices are usually issued in humanitarian cases when you file for a U visa, when you file for VAWA. So they help you to basically show that you may have married in that area, and they say that you can qualify for public benefits, but I think with new laws that's been cut off. Okay, so that's what those things mean. Hi, Patchforge, жду TPS, уже одобрено 130 интервью по браку с гражданкой через 3 недели. Каковы шансы? Брак реальный. All right, the person is asking what the chances of getting adjustment of status based on marriage if they file for TPS. Смотрите, здесь все зависит от того, как вы заехали в США. Если вы заехали легально, и у вас реальный брак, и вы можете это доказать, вы хорошо подготовились к своему интервью, то у вас будут хорошие шансы. Плюс, конечно же, нужно знать вашу иммиграционную историю. Были ли вы когда-нибудь в суде? Надеемся, что нет. И уголовную историю. Были ли против вас выдвинуты какие-то обвинения когда-нибудь? So, the chances of getting adjustment of status depends on your criminal history, your immigration history, inadmissibility issues. Have you ever been charged with a crime? Can you become a public charge? Right? Did you enter the country legally with a visa or parole? It's very important. And then if everything checks out and your marriage is real and you well prepared for the interview, you documented that your marriage is real well, then you're good. You'll be fine. Okay. And also if you were free to marry when you married. Many denials I see right now from people who said long time ago when they're first filing for their visa to come to the United States that they were married, but it was not true. Now they're filing for a green card based on marriage with a US spouse, real marriage, but they cannot prove that they divorced that person that never existed. Guys, just admit to fraud, file for the waiver. Don't make your life complicated, okay? All right. What do they ask in an N400 interview if a green card is based on asylum? They can ask you about your asylum claim to verify that you are, didn't cheat them. They will verify how you answered at that time and now to questions about your membership in different groups. And don't think that for them asylum process is confidential. For them, your asylum process is not confidential. They will have your file, they will read it, they will ask you questions about it. Right? All right, let's see what else we have. Can I file in 400? I have I-751 pending since 2022. Me and my husband don't live together and not divorced. Yes, if you qualify for a waiver-based I-751, based on other grounds than divorce, sure, you can go for it. And why? Because you see, the government is not going to grant you N400 until they grant you I-751. And to grant you I-751, you need to qualify, since you no longer have viable marriage, for I-751 based on waiver-based grounds. Okay? All right, let's see, guys, from YouTube. Hi, Dottie. We did our interview, I-45 based green card, and now they send us a second interview letter. Not good. On my husband's name, who is a US citizen, for I-130 interview. Why? What do you advise us? Most likely it's going to be Stokes interview. Second interview, well, in New York, it's called Stokes interview. It's when they separate you and they ask you separately questions, and then they verify the answers. They compare the answers. They allow you like 10% or something or so to be mismatched. But if too many questions are not answered the same way, then they make a determination that your marriage is not bona fide. Sham marriage. And that's it. It's like a bar for the person who's a non-citizen to ever get a green card. So prepare very, very well. And bring additional documents proving real marriage. Hi, Augustine. My lawyer didn't receive my interview notice for I-45. The denial letter states, that's correct. I just spoke about this. The Niles letter says that I missed my interview and I was living in the United States, contrary to law, when I filed I-45, but I-360 were approved. What can I do? Well, I'm going to tell you, most likely you're going to end up in removal proceedings. This is something that I exactly spoke about now. Most likely you can try filing motion to reopen. I think you should. Maybe you will be lucky and they will adjudicate it before they issue a notice to appear. But most likely you will have to finish your case in immigration court. Okay. Hi Ahmed, how can I connect VAO Center without my lawyer? Because my lawyer withdrew from my case without giving me time to find another lawyer. I want to send mail to them. Should I notarize a letter? Oh yes, Ahmed, you should notarize a letter advising them that this is your new safe mailing address, and you have to notarize your letter because otherwise they're not going to communicate with you. Okay. Hi Ekaterina. How safe is to travel with a refugee travel document? Status is granted by USCIS, never been to court, no crime, but we don't have green card so far. I have never heard that someone who has a refugee travel document was not allowed to go back, to come back, enter back the United States. So I think that you should be able to travel with no worries whatsoever, especially if you don't go to the country of persecution. Okay. All right, guys, let's see if we have more questions. Are you from Ukraine? No, I'm not from Ukraine. Let's guess. Make your best guess. Where do you think I'm from? But I'm not from Ukraine. My case updated to actively reviewed after my marriage green card interview yesterday. Panicking. Why? Why are you panicking? Don't check those case updates at all. They only mean anything if they state an error fee was sent to you or notice for the interview was sent to you. If that's not released, all those updates actively reviewed, next step is the interview, it's garbage, right? Garbage. Hi, what are the main reasons citizenship getting delayed? Now 8 months, no update. Main reasons. Well, it may be that you filed for a waiver of the English language requirements. But you're asking this question in English, so I don't know. So if you file for that waiver and they accepted it these days, it's like a nightmare. They just do not want to approve those cases. They may also check your previous immigration history, especially if you got your green card based on asylum. Those cases usually take longer because they have to make sure they are admitting you and they are not making a mistake. They will verify all the applications, find different inconsistencies. If there are any, will determine if it is worth it for them to try to place you back in removal proceedings or in removal proceedings to try to argue you committed fraud. That's what's going on. Okay. All right. Can I file in for 100 years? We talked about that. All right. Andrew says that he entered the United States riding a white horse. As long as you stopped riding the white horse, you'll be fine, okay? So let's see. They call me today on my way for my interview and say, sorry, the interview is canceled. Yes, Maybell, it may happen. It may happen that your interview will be canceled at the last minute. As long as you have proof that they're the ones who told you that, you'll be fine. You see, sometimes they say that it's canceled, but somehow in their system, they like 2 months afterwards, they don't really register that they called you. So it's a very tricky situation. After I've seen a couple cases of this sort, I always tell clients you show up and get proof that it canceled. Get proof from the supervisor. All right, because I don't like phone calls. Nah, I don't know. You know, I wouldn't trust that. I'm sorry. I wouldn't trust that. All right. Let's see. Hi, Natural Vibes. Hello. Guys, if you need a more detailed answer to the questions, please call my office, schedule an appointment. We'll be very happy to spend time with you, go over your cases, okay? This is just a couple of tips for you so you know what to expect. All right. Hi, Natural Vibes. Hello, ma'am. If someone has CGs, I-360 with deferred action, can he still say? Can he still save from deportation? Well, if the deferred action is not revoked, the person should not be deported, right? I know that recently there is this issue with such petitions where some judges do not terminate the cases, but most judges will terminate the case and allow you to adjust before USCIS, okay? So you need a good lawyer argue on your behalf. That's what I would say you need to do. Hi, Ion N4. I applied I-45 based on asylum 14 months ago. Any idea how long it will have to take more? Are people getting approvals? I've heard that some people do get approvals, but I do not know how long it's going to take. I think it differs in every case. How did you receive it with USCIS or with the judge? What potential issues could have been uncovered? Listen, even before Trump administration, it's always been the case that they would check all the information that you shared. Sometimes they find fraud even after you won the case with the judge. Like a person would say that I was in my country on such and such date, but then the government finds records that they were in Costa Rica on such and such date. What's going to happen? Nothing was going to happen afterwards. But that's what it is. All right, that's what it is. So they do take time checking everything. Okay. Now let's see if we have more questions here on TikTok. Hi, Sayak. If you guys have immigration questions, let me know. All right. Let's see if you have more questions. All right. Lloyd didn't receive the interview notice. I know. I know. We're seeing that. As I said, they could have not sent you any interview notice, but they registered yours. You didn't show up. I totally get it. And I'm telling you, filing motion to reopen is a good option, of course. If you are lucky and they adjudicate it fast, then you are not going to be sent in removal proceedings. But sometimes you're not so lucky and you get that NTA before they can figure out what to do with you. All right. Do you know anything about CHNV program? I honestly don't know any updates with regard to that. I won't lie here. Can they make decisions on your master court hearing? Oh, they can make those decisions, all right, especially now. If you filed asylum case, they can make decision, okay? They can close your case. They can close your case saying that your case is nothing, garbage. They say it's called pretermit your asylum claim. So I always advise to redo your I-45 if it didn't have meaningful information in it. At least your story, preferably to be attached by the master hearing. But if you need a little bit more time on it, then forget it. But at least redo your I-45 so it has complete answers to all the questions. All right. They also can make decisions to administratively close your case or terminate your case sometimes. It depends on the situation. Okay. Hi, Veronica. You can go to your woman where you live. She can contact the USA of our unit for you. Yes, if you can contact through VAWA. Well, VAWA is a little bit different. I mean, I guess you can ask for the congressman assistance, but they will still ask for the release of the information and things like that. So that can happen, yes. Okay. Hi, what's the next after getting I-765 receipt notice for T visa? What can you do? You'll have to wait for the decision to be made on your case, on a T visa case. That's what you'll have to do. All right. All right, guys. Let me know if you have more questions. We're going to be wrapping up. Today we discussed adjustment of status problem that is happening these days. You file for adjustment of status and instead you are you find yourself in removal proceedings and you're thinking like, what did I do wrong? How is it possible, right? But it happens sometimes. Is it possible to receive my green card via mail without getting a notification on my USCIS portal? Yeah, sometimes it's possible. Sometimes the portal is not getting updated. I've seen cases where the person already has a green card, but the portal still says interview will be scheduled. Okay, so yes, it happens too. What is the difference granted asylum by USCIS and immigration judge and impact on I-45? Depends on agency, depends on questions, answers. I-45, sorry, with the judge, it means usually that um, there's a transcript of questions, answers. Well, there is one, I guess, for asylum interview, but it may be different. USCIS typically would probably have more respect for the judge's decisions because usually when you're in court, the fraud will be uncovered there, all right? Because it's like an extra step that you go through, but not necessarily, of course. As that sometimes they will find out that something went wrong only after even the judge granted the case, all right? So that's what it is. All right, guys, if you are good with questions for today, I wish you all to have a very good night. Please don't forget to sign up for my channels if you're watching me on various platforms. And of course, stay updated, and I hope to see you guys soon.